So, I want you to imagine stepping out of your front door on a Tuesday morning. You've got your coffee in hand, and you look down only to find that your household's garbage has just been deliberately left rotting on the curb.
Oh, wow. That's a rough start to a Tuesday.
Right. And you look down the street, and everyone else's bins are completely empty. So, you call the neighborhood management office to report the missed pickup.
Naturally.
But you are met with this cold, bureaucratic response. They tell you your sanitation services have been suspended. And why? Because a self-appointed committee decided you parked your car incorrectly on a street they don't even legally own.
Wow. I mean, they bypass the local traffic police. They bypass any formal legal system entirely.
Exactly. They just unilaterally decide to kind of weaponize your trash to force you to pay an arbitrary fine.
It sounds like the premise of a dystopian novel about, like, micro-authoritarianism or something. But the wild part is it is a documented reality.
Yeah, which is exactly why we're doing this deep dive today.
Right. Because the situation you just described is actually the natural endpoint of a very specific, very common phenomenon. We see it all the time when a group of well-meaning neighbors forms a committee to manage, say, a shared park or a swimming pool.
And then it just mutates.
Yeah, slowly, imperceptibly, that mandate mutates. They start viewing themselves not as custodians of shared amenities, but as this miniature sovereign government.
A government that thinks it has the authority to police the private lives, the finances, and honestly, the fundamental property rights of the residents.
Precisely. And today we are dissecting a document that captures this exact mutation in real time.
We really are. So for everyone listening, we have this meticulously argued legal representation. It's titled Request to Freeze Enforcement of Disputed Decisions.
Very formal.
Very. It's dated May 2027, and it's addressed to the President and Secretary of the Vasanthvihar Army Residents Welfare Association.
Which we will just refer to as VVIRWA for short.
Yes, VRWA. It's a residential community located in Bengaluru. And the author of this document, who is clearly very well versed in constitutional law, has basically served the neighborhood's managing committee with this massive legal takedown.
I mean, it is a comprehensive dismantling of their entire governance structure.
Yeah.
And the central mission of our deep dive today is to unpack the legal concept that really anchors this whole document.
Right, which is ultra-virus.
Exactly. Ultra-virus, it's a Latin phrase, and it literally translates to beyond the powers.
So acting outside your jurisdiction, basically.
Right. In a legal context, an act is ultra-virus if it's done without legal authority.
Yeah.
So if a corporation or a government agency, or in this case, a residents' welfare association, takes an action that exceeds its granted power.
Like the power granted by its founding charter.
Yes, or by the law of the land. If it exceeds that scope, that action is legally void. It's like it never legally happened.
That's wild. So this Bengaluru community is basically providing us with this fascinating high-stakes case study. We're seeing what happens when the mundane tasks of neighborhood management just collide head-on with the constitutional rule of law.
It's a massive collision. And to frame just how severe this collision is, there's a supplementary note attached to our primary source.
Oh, right. The part about the May 4th minutes?
Yeah. The author states that the minutes from the community's May 4, 2026 meeting fail what they call a lodestar stress test.
Now, just to clarify for you listening, a lodestar is historically a guiding star, right? Usually Polaris, which navigators use to find true north.
Exactly. So in a legal sense, a lodestar principle is that fundamental guiding standard against which all actions have to be measured.
And the author is arguing that the committee's actions completely fail to align with those guiding principles of lawful governance?
Completely fail. The note actually goes even further. It states that by enforcing these arbitrary rules, the committee has crossed the Rubicon of rule.
The Rubicon, that's a heavy metaphor.
It is, but it's crucial to understand the author's mindset here. I mean, when Julius Caesar crossed the Rubicon River with his army, it was an act of treason.
Right. It committed him to civil war. It was the absolute point of no return.
Exactly. So by applying that specific metaphor to a homeowners association, the author is signaling that this isn't just about a few minor administrative errors.
They haven't just filed the wrong paperwork.
No, they have fundamentally altered their relationship with the residents. They've crossed the boundary from acting as a contracted service provider to acting as a coercive authoritarian regime.
Which is terrifying. And the question for you, listening to this deep dive, is to really consider the mechanisms of authority in your own life. What actually happens when a residential committee crosses that Rubicon?
And more importantly, how does the law rein them back in?
Right. But before we get into the bizarre specifics of the garbage strikes and the parking fines, I feel like we need to establish the baseline rules of reality here.
Definitely. We have to look at the architectural framework of this organization.
According to the document, VVRWA is a registered society. It operates under the Karnataka Societies Registration Act of 1960.
Right. And the author establishes right out of the gate that VROA is a private association. It is not a sovereign body.
But what does that distinction actually mean in practice? Like, where does a society's power begin and end compared to, say, a city council?
Well, the distinction really comes down to this concept of inherent power. A sovereign state, meaning a national or regional legislature, possesses inherent police powers.
Okay, so they have a broad mandate to pass laws.
Exactly. They can pass laws for the health, safety, morals, and general welfare of the public, and they are constrained only by a constitution.
So if a city council wants to pass a zoning ordinance or levy a new tax, they have the inherent constitutional authority to just initiate that process.
Yes. But a registered society operating under the 1960 Act has absolutely zero inherent power. None.
Wow, zero.
Zero. They don't have a general mandate to govern anyone. They are strictly a creature of contract and statute. Their authority exists entirely within a closed loop.
And the document lays out that closed loop very clearly, right? It states that the association's authority can only flow from very specific, verifiable sources.
Right. It has to come from the overarching statutes, like the 1960 Act itself, or from the registered rules and bylaws of the society.
Or I guess from validly passed resolutions by the general body.
Yes, provided those resolutions do not conflict with the law. And finally, it has to comply with general public law, meaning municipal regulations and constitutional rights.
So basically, if a new neighborhood rule cannot trace its origin back to one of those specific legal wellsprings, it is ultra vires. It's void.
It is completely void, which brings us to the core dysfunction the author identifies in this community.
The managing committee, the MC.
Right. The MC has established a governance pipeline that completely ignores those legal wellsprings we just talked about. The representation actually terms it the agenda point to MC decision pipeline.
This pipeline concept is so fascinating to me. So basically, the committee holds a standard monthly meeting, right?
Yeah, just a regular Tuesday night meeting.
Right. And a member brings up an agenda point. Maybe they're annoyed by how many renters are moving in, or they don't like where people are parking.
Typical neighborhood gripes.
Exactly. So the committee discusses it, they agree it's a problem, and they literally just type up a decision in their meeting minutes.
And that is the fatal error. Because from that moment on, they treat that typed sentence as an enforceable law.
It's insane. It's like a local book club deciding they are tired of people showing up late, so they just write down in their spiral notebook that anyone tardy owes the club $50.
Right. And then they actually expect to be able to collect on it through a collection agency or something.
Yeah, they are attempting to conjure legal authority simply through the act of writing something down in a meeting summary.
And the mechanism you're describing highlights this profound misunderstanding of what meeting minutes actually are.
Which is what, exactly?
Well, in corporate and administrative law, minutes are just evidentiary documents. They're a historical record.
Just a record of what was discussed.
Exactly.
Yeah.
What was discussed and what administrative steps were agreed upon. They are not legislative instruments. You cannot generate new powers, levy new taxes, or restrict property rights simply by narrating your desire to do so in a monthly record.
Because the actual process for changing the rules of a society under the Karnataka Societies Registration Act is deliberately rigorous, isn't it? To prevent exactly this kind of casual tyranny.
Oh, it's incredibly rigorous. The author details the process, and the friction is palpable. If the MC actually wanted to legally change a rule,
say to impose a new recurring fee on everyone.
Right. They cannot just do it on a Tuesday night with the 5 people sitting on the board. They have to convene a special general meeting.
Which means giving notice, I assume.
Yes, 21 days of written or printed notice to every single member. And that notice has to clearly outline the proposed change.
Wow, every single member. And the hurdle for passing that change is massive too, right?
It really is. It requires a special resolution. Under the statute, it must pass by a margin where the votes in favor are not less than 3 times the votes cast against it.
Wait, 3 times? So that's a 75% supermajority of the voting members present.
Precisely. And even after achieving that supermajority, the newly minted rule is still not immediately active.
You're kidding. What else do they have to do?
It must be formally filed and registered with the government registrar to ensure it actually complies with broader state laws.
Okay, let me play devil's advocate and push back on this framework for a moment, because while it sounds great in a law school classroom, think about the reality of managing a neighborhood of over 400 homes.
It's definitely a logistical nightmare.
Right. If you have to wait a month and mobilize a supermajority of residents just to address a new emerging nuisance, like, let's say, a sudden influx of loud, late-night commercial deliveries to a specific house.
That would be incredibly disruptive.
Exactly. The neighborhood would descend into chaos before the bureaucracy could catch up. So isn't this rule-by-minutes pipeline just a necessary adaptation?
You mean, are they just being pragmatic?
Yeah, aren't these volunteer committee members just choosing pragmatic speed over paralyzing legal friction?
I see your point. You're hitting on the fundamental tension of all administrative law, which is the friction between efficiency and due process.
Because from the perspective of the committee, dealing with a nuisance via an immediate mandate in the minutes probably feels like effective leadership.
Oh, I'm sure it does. But the problem with prioritizing pragmatic speed over legal friction is that the friction is there by design.
It's a feature, not a bug.
Exactly. That 21-day notice and that 75% supermajority requirement. They exist specifically to protect the minority of property owners from the sudden emotional whims of a transient majority or a reactive committee.
So when you bypass the friction, you bypass the protection.
Completely. If a committee can unilaterally restrict a property right today, just for the sake of convenience, they can unilaterally confiscate one tomorrow. Speed in governance, when it's unmoored from statutory authority, is indistinguishable from autocracy.
Which is a chilling thought. And the document actually moves from the theoretical danger of this autocracy right into the tactical methods the committee uses to enforce it.
Yeah, they aren't just writing illegal rules in their minutes. They are employing communication strategies designed to stifle any challenge to those rules.
Like the do not reply email address. The author highlights that they use a no-reply email to distribute these binding minutes.
The one-way dispatch. In modern digital governance, the no-reply email is an incredibly aggressive tool.
It really is. Think about it. You receive an email dictating a new restriction on your property or levying a new financial charge on you, and the architecture of the communication literally prevents you from responding.
Right, it's designed to silence you. And the author includes a brilliant piece of analysis on this. They state that legitimacy cannot be manufactured by disabling the reply function.
I love that phrasing. Legitimacy cannot be manufactured.
It's spot on. A one-way email dispatch does not legally establish that the members have consented or even acquiesced to the new rules. It merely proves the data was transmitted.
It just proves the server sent an email. That's it.
Exactly. The legal concept at play here is the right to be heard, which is a core tenet of natural justice.
So if a body makes a decision that negatively impacts you, you have to be able to respond.
Yes. When an administrative body makes a decision that impacts an individual's rights or finances, that individual must have a clear, immediate channel to challenge the premise of the decision.
And by using a no-reply address, the committee is just attempting to manufacture a landscape of silence.
And then they try to interpret that forced silence as unanimous agreement.
It's so manipulative. But the residents are finding ways to object anyway, and how the committee handles those formal objections is even more insidious than the no-reply emails.
Yes, the author analyzes a specific set of minutes from April 18th, 2026. And these minutes reveal a highly performative handling of dissent.
Performative is the perfect word. A resident will submit a detailed objection challenging the legal basis of a new rule, right?
Right.
And the committee actually types out the resident's objection in the minutes. They record the dissent textually, but immediately below it, in a column labeled decision, the committee just issues a one-sentence decree that entirely ignores the legal substance of the objection.
It is the absolute illusion of due process. They are confusing the act of hearing with the act of listening.
By recording the objection, they want to appear transparent and democratic.
But by failing to address the merits of the argument, they are demonstrating absolute administrative arrogance. And the author of the representation points out that this tactic actually creates massive legal liability for the committee members.
Wait, how does acknowledging the complaint make them more liable? I would think ignoring it entirely would be worse.
Well, because recording it destroys the defense of ignorance.
Oh, I see.
Yeah. If a resident formally informs the committee that a specific action violates the Karnataka Society's Registration Act, and the committee records that warning in their own official minutes,
Then they can never claim in a court of law that they didn't know.
Exactly. They can never claim they were unaware of the legal defect. They have created a permanent written record proving that they were put on notice regarding their ultra-vires behavior.
And they consciously chose to proceed anyway without addressing it.
Right. It transforms a potential administrative error into deliberate documented overreach.
Wow. So to counter this overreach, the legal representation breaks down the anatomy of what a lawful, reasoned decision must actually look like.
Yes, they present 5 specific questions that a committee must answer on the record whenever they impose a rule or penalty.
And these aren't just like good ideas. They are the baseline requirements for administrative validity. Let's go through them.
Those 5 questions are essential. First, what is the exact legal source of power being invoked? They must move beyond vague appeals to community standards and cite the specific legal authority.
Okay, so cite the actual law. What's the second?
Second, what precise bylaw or statutory provision is being applied? They need chapter and verse.
Makes sense.
Third, what facts were established after hearing both sides? A committee cannot operate on presumption. They must conduct a basic fact-finding process.
Right. They can't just assume someone is guilty because they don't like them.
Exactly. Fourth, why is the resulting action proportionate and non-discriminatory? They must demonstrate that the punishment fits the alleged violation and that the rules applied equally to all residents, not just targeted individuals.
And the fifth question is arguably the most critical for the residents feeling trapped by this system, isn't it?
Oh, absolutely. The fifth question is, what is the mechanism for appeal?
Where does a homeowner go to seek redress if they believe the committee's fact-finding was flawed or their authority was lacking?
And currently, the VVRWA committee is answering 0 out of these 5 questions.
0. They are operating in an environment entirely devoid of reasoning, which really sets the stage for the most compelling legal argument in the entire document.
Yes.
So we have established that the managing committee cannot create laws out of thin air in their monthly meetings. But the committee frequently counters this by pointing to the annual general body meeting, the AGM.
The AGM defense.
Right. They argue that many of these contentious rules were presented at the AGM, voted on by the community, and passed by a majority. They used that democratic mandate to shield themselves from accusations of overreach.
And this is perhaps the most widespread and dangerous misconception in the realm of private associations. It's this belief that a majority vote cures all legal defects.
It's so common. But the author of the representation addresses this head-on with a sentence that really serves as the philosophical anchor of the document. They write, "With respect, an AGM is not Parliament."
It is a phenomenal distinction.
It really is. I mean, we are so conditioned by democratic systems to accept that majority rule is the ultimate arbiter of legitimacy. If 51% of the people vote for something, it becomes the rule.
But the author is violently severing that connection in this context. We have to unpack what powers Parliament actually holds to understand why an AGM falls so short.
Right. What's the difference in power there?
Well, a national parliament, operating under Constitution, has the sovereign power to pass sweeping legislation. They can fundamentally alter property rights, impose massive tax burdens, regulate civil liberties.
Because they have checks and balances.
Exactly. They are checked by a constitution, a judiciary, and an electorate of millions. An annual general body meeting of a localized housing society possesses none of those checks, balances, or inherent sovereign authorities.
So they can't just vote to take away my rights. The document is incredibly precise about the boundaries of an AGM's power. It states unequivocally that even a unanimous vote at an AGM...
Even if every single homeowner raises their hand in agreement.
Right. Even then, that vote cannot override fundamental statutes. An AGM resolution cannot invalidate the Transfer of Property Act.
It cannot override local rent control laws.
Or bypass the regulatory framework of the Karnataka Society's Registration Act. And most significantly, it cannot override Article 300A of the Constitution of India.
Article 300A is the bedrock of this entire argument.
For context, for those listening, Article 300A mandates that no person shall be deprived of his property save by authority of law.
And in this context, law means a statute passed by a competent legislature, not a resolution passed by a neighborhood committee.
Right. When you purchase a property, you acquire a bundle of legally protected rights. The right to possess it, the right to modify it within municipal limits, and critically, the right to lease it.
Yes. Let's ground this in a practical scenario so it's easier to visualize.
Okay, let's do it.
Suppose you own a home in a gated community, and your house has a large, legally permitted driveway. You decide to park a small, brightly colored commercial van in your driveway because you own a plumbing business.
Okay, I've got my neon green plumbing van.
Right. Aesthetically, your neighbors hate it. So at the next AGM, a motion is introduced to ban all commercial vehicles from being parked anywhere in the neighborhood, including private driveways.
And let's say the motion passes with an 80% majority. According to the logic of the committee, I now have to move my van.
But according to the legal representation we are analyzing, that vote is meaningless.
It's totally void.
The vote is completely void because it attempts to act as private legislation. A majority of your neighbors cannot contractually strip away a fundamental incident of your property ownership, your right to use your legal driveway for a legal vehicle, simply because they find it distasteful.
So this analytical framework requires us to draw a hard line between community management and private legislation. But where exactly is that line? Because clearly an HOA must have some power to regulate the environment, right?
Yes, of course. Community management deals with the administration of shared, common resources and the regulation of actual provable nuisances.
Like the clubhouse hours.
Exactly. An AGM can absolutely vote on the operational hours of the clubhouse. They can vote to increase the maintenance fees to repair the shared roof of an apartment block.
Or establish a rule requiring dogs to be leashed in the common parts.
Right, because those are management issues intrinsic to a shared living arrangement. Private legislation, however, occurs when the association attempts to dictate the lawful use of the private individual units.
In a way that is not explicitly authorized by the founding bylaws or the overarching law of the land.
Precisely.
So regulating the color of the flowers planted in the common roundabout is management. Banning me from renting out the second floor of my legally constructed home is private legislation.
Exactly. And that specific example, the restriction of tenancy, is actually the first of 3 highly detailed case studies the author presents from the April 18th, 2026 minutes.
To demonstrate how far VVRWA has strayed into private legislation, let's look at that ban on multiple tenancy and floor-wise leases.
Yes, this is a major point of contention.
So the document highlights a confrontation triggered by an agenda point from a resident in Pocket 138. And just for clarity, a pocket in this context refers to a specific geographic cluster or sector of homes within the larger Vicenth Vihar layout.
Right, like a sub-neighborhood.
Exactly. This resident from Pocket 138 formally challenged a blanket ban that the managing committee had imposed on floor-wise tenancy.
The committee had essentially declared that owners were forbidden from renting out separate floors of their individual houses to different tenants.
And the justification the committee provided for this sweeping ban is such a classic example of administrative overreach disguised as logistical necessity.
It really is. They pointed to the layout's designed capacity of 424 dwelling units.
Right. Their argument is that the civic infrastructure, the water supply, the sewage capacity, the road width was engineered for exactly 424 single-family units.
So by allowing an owner to rent out a ground floor to one tenant and a first floor to another, the committee argues that the owner is illegally subdividing the property.
They're saying it artificially increases the population density and places this unbearable strain on the shared infrastructure.
And honestly, on its face, the infrastructure argument sounds completely rational.
Right. If a system is built for 400 families and suddenly you have 800 families living there because everyone is renting out their basements and second floors, the pipes are going to burst. The power grid is going to fail.
Doesn't the association have a fiduciary duty to protect the infrastructure from that kind of stress?
They have a duty to manage the infrastructure, yes. But the legal representation systematically dismantles the premise that a blanket ban on floor-wise leasing is a lawful or proportionate way to fulfill that duty. The author anchors the counterargument in the Transfer of Property Act. As we discussed with Article 300A, ownership inherently includes the right to lease.
Right. So subjecting that fundamental right to a total prohibition based on a theoretical infrastructure strain just fails the legal test of proportionality.
Exactly. And the author introduces this really compelling socioeconomic reality into the legal argument. They point out that urban infrastructure is inherently designed to accommodate variable occupancy over decades.
That makes sense. A 4-bedroom house might be occupied by a family of 2 or a multi-generational family of 8.
Right. The municipal authorities recognize this reality. They already possess mechanisms to assess and tax properties based on partial or rented usage. The demographic makeup of a neighborhood is naturally fluid.
And that fluidity exposes the flaw in the committee's logic. If a family of 8 living in one house does not violate the design capacity rules, but a homeowner renting their separate floors to 2 different couples totaling only 4 people triggers a ban.
Then the committee is not actually regulating infrastructure strain at all.
No, they are attempting to enforce a specific demographic and social model. They are deciding what a proper household looks like.
Which is way beyond their power. The legal expert explains that for the committee to lawfully intervene, they cannot rely on a blanket prohibition. They must prove concrete, individualized harm.
So the legally relevant inquiry is not whether the occupants fit a traditional nuclear family structure.
Right. The inquiry is twofold. First, has the physical dwelling unit been illegally and structurally altered to create separate units without municipal sanction?
Like building a second kitchen without a permit.
Exactly. If an owner illegally reroutes plumbing, the municipality can intervene. And second, is the specific arrangement creating a documented, provable nuisance or safety hazard?
So if the tenants are hoarding garbage and causing a health hazard, the association can address that specific nuisance.
Yes, but the committee cannot preemptively extinguish the right to lease under the guise of an infrastructure concern. Absent proof of actual individualized harm or a specific municipal violation, a blanket prohibition on floor-wise tenancy is ultra-vires.
It is an unlawful restriction on a primary incident of ownership. It is, to return to our earlier discussion, private legislation.
And this tendency of the committee to treat different classes of residents differently brings us seamlessly to the second case study, which exposes a glaring attempt at private taxation.
Oh, the discriminatory tenant surcharge. Let's get into this one.
The VVCC charge. This is a textbook example of an administrative body attempting to generate revenue without representation.
According to the document, the managing committee passed a resolution imposing an additional recurring financial levy of 250 rupees per month, but specifically on tenants residing in the community.
Let's lay out the financial realities of this community to really understand why this is so egregious. Every property owner in VVRWA is already obligated to pay a monthly maintenance charge, the MMC.
Right. And this MMC is calculated to cover the operational costs of the association, right? Security, common area lighting, road maintenance.
And the upkeep of facilities like the Vasanth Vihar Community Center, or VVCC. And the owners pay this fee regardless of whether they live in the house or rent it out.
So when the committee imposed the extra 250 rupee VVCC charge on the tenants obviously formally objected.
And their logic was unassailable. They raised 3 primary points. First, many of the tenants do not even utilize the community center facilities.
Makes sense. Second, the cost of maintaining those facilities is already theoretically embedded in the primary maintenance charge paid by their landlords.
Right. And third, which is the most critical governance point, tenants are disenfranchised within the structure of the association.
They have no voting rights at all.
None. They cannot attend the annual general body meetings. They have no mechanism to audit the association's finances, scrutinize the budget, or demand an accounting of how their 250 rupees are being spent.
They are entirely excluded from the democratic process of the society. So when these disenfranchised residents pointed out the apparent illegality of this targeted tax, how did the managing committee respond in their April 18 minutes?
Oh, this response perfectly encapsulates the rule-by-minutes dysfunction. The committee did not justify the charge. They didn't point to a bylaw authorizing it.
Let me guess, they didn't present an accounting spreadsheet either.
Nope. No spreadsheet showing a deficit in the budget. Their decision simply stated that moving forward, the association would stop invoicing the tenant directly for the VVCC charge and would instead add the 250 rupee surcharge to the property owner's monthly maintenance bill.
Wow. I want to pause on that because the administrative sleight of hand is staggering. They completely ignored the question of legality.
They didn't solve the problem at all. They just changed the mailing address on the invoice.
It is a profound evasion of accountability. By shouldering the billing to the owner, the committee assumed they had neutralized the conflict, believing the owner would simply pass the cost onto the tenant in rent.
But the legal representation dissects this maneuver mercilessly. Changing the payer does not alter the fundamental legal nature of the charge. The author frames this as an unauthorized, micro-level form of taxation.
Because to legally justify a recurring levy on occupancy, essentially a user fee, the committee must answer the foundational questions we discussed earlier.
Right. What specific registered bylaw grants the association the power to lever a secondary distinct tax on a specific demographic of occupants?
And if the fee is for the community center, why is it compulsory for tenants who do not use it, while owners who do use it do not pay a secondary fee?
It's totally arbitrary. Without a clear statutory basis and without a direct mathematical correlation to specific usage or consumption, the 250 rupee charge is not a lawful user fee.
No, it is an arbitrary, discriminatory surcharge levied on an individual's status as a renter. The committee identified a subset of the population that lacked the political power to vote them out and decided to exploit them as a distinct revenue stream.
It is the very definition of an ultra vires action.
It really is.
Now, while the tenancy ban and the tenant surcharge are blatant violations of property and financial rights, the third case study highlighted in the document represents a total collapse of civil governance within the community.
Yes, this one is wild. It involves parking fees and what can only be described as the weaponization of municipal sanitation.
Weaponized garbage. This incident revolves around a representation submitted by a resident named Brigadier Dr. A. Sridhar, residing in Pocket 249.
The conflict originated when the managing committee decided to levy a penalty fee of 1,500 rupees per month on vehicles that were deemed to be permanently or semi-permanently parked on the internal roads of the layout.
But before we even get to the penalty itself, Brigadier Sridhar raised a devastating jurisdictional question. He pointed out that the internal roads where these vehicles are parking are not actually owned by the Vasant Vihar Army Residents Welfare Association.
Wait, really? They don't even own the roads?
They don't own the roads. The association is attempting to enforce a parking regime and collect revenue on land they do not possess.
It is a breathtaking assertion of authority. The committee is treating public, or at least non-association, thoroughfares as monetizable assets belonging to the society.
And furthermore, Brigadier Sridhar meticulously deconstructed the language of the rule itself. Because the phrase, permanently or semi-permanently parked, is a masterclass in administrative vagueness.
It is entirely subjective. I mean, what is the legal definition of semi-permanent? Is it a car that hasn't moved in 3 days? A week?
Or is it a vehicle that is driven to work every day but parked in the exact same spot every single night?
Right. When a rule is that vague, it cannot be enforced uniformly. It practically guarantees that enforcement will be arbitrary and driven by the personal biases of whoever's walking around with a clipboard.
And indeed, the resident alleged that the committee was selectively exempting certain favored owners from this fee, rendering the entire policy discriminatory.
But, the jurisdictional overreach and the vague drafting of the rule are almost secondary to the enforcement mechanism the committee allegedly deployed.
Oh, this is the craziest part. When a resident contested this legally dubious parking fee on a road the association does not own, the committee did not file a civil suit.
They didn't seek mediation.
No. According to the document, they retaliated by halting the collection of household garbage from the offending resident's home.
They initiated a targeted sanitation strike. They took an essential service, the removal of rotting biological waste, which is a service fundamental to public health and basic human dignity, and transformed it into an instrument of coercion.
The author of the representation identifies this as the absolute nadir of the committee's governance. The severance of essential services is a draconian measure.
In broader legal context, even when a tenant is months behind on rent, a landlord cannot unilaterally cut off water or electricity without a court order, because those services are essential to human habitation.
So for a neighborhood committee to weaponize sanitation over a disputed subjective parking fee is a profound violation of natural justice.
And the execution of this punishment reveals a deeply disturbing shadow structure within the association, because the restriction of garbage collection was reportedly overseen by an individual holding the title of a pocket secretary.
A pocket secretary. Let's unpack the implications of that person executing this kind of penalty. This individual is not a judge. They are not a trained municipal officer.
No, yet within this micro-fiefdom, this single person is functioning as the investigator who spots the parking violation,
Right.
the prosecutor who brings the charge.
The judge who decides guilt based on a vague, semi-permanent standard, and the executioner who orders the sanitation workers to bypass the home.
It is the complete consolidation of power, totally devoid of any checks, balances, or due process. There is no formal hearing, no presentation of evidence, no impartial tribunal.
There is simply the decree of a local representative enforcing an ultra-vires rule through coercion.
So given the severity of these allegations acting outside their jurisdiction, drafting unenforceable rules, practicing discriminatory enforcement, and holding essential public health services hostage, how did the managing committee respond to Brigadier Sridhar in their official minutes?
Their response in the April 18 decision column is just an exercise in bureaucratic evasion. They offered 2 brief points. First, regarding the legality of the parking fee itself, they stated that the issue would be referred to the upcoming annual general body meeting for ratification.
Which, as we have exhaustively established, is legally meaningless.
An AGM is not parliament. A majority vote in a community hall cannot retroactively grant the association jurisdiction over roads they do not own.
Nor can it cure a fundamentally vague and discriminatory policy.
Exactly. And their second point regarding the weaponization of garbage was merely a passive statement that essential services will not be disrupted.
Oh, notice the careful construction of that response. They did not admit fault.
No apology.
They did not acknowledge that suspending sanitation was an unlawful and coercive abuse of power. They did not establish a formal policy prohibiting the use of essential services for retaliation in the future.
They simply offered a temporary placating assurance without addressing the underlying collapse of the rule of law.
It is a very bleak landscape.
It really is. We have traced a path from the seemingly innocuous practice of writing rules in a meeting minute, down through the bureaucratic stonewalling of do-not-reply emails, all the way to the petty tyranny of weaponizing household waste.
It just illustrates how rapidly a community can degrade when it prioritizes the convenience of control over the friction of lawful governance.
But, the document we are studying, authored by Chandra Nath, is not merely a catalog of grievances. It is not just a complaint.
Right, there is a solution proposed.
Yes, the final section of the representation provides a meticulous, highly structured roadmap to reform. It offers a blueprint for how a broken, ultra-virus system can be systematically dismantled and brought back into alignment with the rule of law.
And that requested relief section is a masterclass in constructive strategic legal architecture. The author understands that simply demanding the committee resign or stop their actions will likely just result in defensive entrenchment.
So instead, the representation lays out a sequence of procedural reforms that provide the committee with a mechanism to de-escalate the conflict and correct their legal posture. Let's examine this roadmap.
Okay, what's the first demand?
The first demand strikes at the root of the dysfunction. The author insists that the managing committee formally acknowledge in their next set of minutes and in a widespread circular to the community that committee minutes are merely a historical record of discussions.
They must publicly disavow the agenda-pointed decision pipeline.
Exactly. They must formally concede that minutes are not and cannot be independent sources of legal authority or private legislation.
The second demand is for an immediate freeze. The author requests an absolute halt to the enforcement of all the disputed decisions we have discussed today.
So the collection of the discriminatory tenant surcharge, the enforcement of the blanket ban on floor-wise leasing, the arbitrary parking penalties,
And crucially, any threat to restrict essential services. All of it must be frozen.
and the freeze must remain in effect until when?
Until the committee can either cite a specific, validly registered bylaw that authorizes the action, or until they successfully navigate that grueling 21-day supermajority process required by the Karnataka Societies Registration Act to actually change the rules.
The third pillar of reform addresses the communication breakdown. The author demands the immediate eradication of the do-not-reply culture.
It's about time.
They mandate the institution of a transparent bidirectional objection mechanism. Moving forward, minutes and decisions must be circulated from an email address capable of receiving replies.
That's huge. Furthermore, there must be a defined protected window. The author proposes 15 days during which members can review the published minutes, identify errors, and submit formal legal objections.
And this objection window is not merely performative. The committee is demanded to maintain a formal objection register.
Right, so when a resident raises a concern about the legality of decision, the committee cannot simply type the objection into the minutes and issue a one-sentence dismissal anymore.
They are required to engage with the substance of the complaint and provide a written, reasoned response before proceeding with enforcement.
Which naturally leads to the fourth, and perhaps most structurally significant administrative reform, the demand for speaking orders.
The concept of a speaking order is fundamental to transparent administrative law. For those listening, a speaking order is a written decision or directive that literally speaks for itself.
It must be a self-contained document that explicitly answers those 5 questions of lawful governance we outlined earlier.
Right. So before the pocket secretary can issue a fine or declare a violation, they must produce a document that clearly cites the specific registered bylaw granting them the power to act.
The document must detail the specific facts that were established regarding the violation. It must explain the logical reasoning connecting those facts to the cited rule.
It must justify why the penalty is proportionate, and it must clearly outline the appeals process available to the resident.
Precisely. A speaking order eliminates the shadows. It prevents arbitrary, subjective enforcement because the logic and legal authority must be laid bare on the page for scrutiny.
And if the legal reasoning is flawed, the order just collapses under its own weight before enforcement can even begin.
Yes. And the final step in the roadmap is focus on long-term systemic health. The author calls for the upcoming annual general body meeting to feature a dedicated agenda item focused entirely on establishing a rule of law and governance framework.
The goal is to initiate a comprehensive project to recodify and consolidate the association's bylaws.
They need to strip away decades of accumulated rule by minutes, put explicit documented limitations on the discretionary power of the managing committee, and construct clear statutory procedures for penalties and appeals that align with overarching state and constitutional law.
Now, I want you listening to put yourself in the position of the president or the secretary of the Viva Ra committee.
Oh boy.
You open your email and you receive this multi-page, heavily researched legal representation. It dismantles your entire method of operating. It calls out your parking fees, your tenant charges, and your sanitation strikes as illegal. What is your reaction?
Do you dismiss it as the ranting of a disgruntled resident? Do you double down and dare them to take you to court?
The author actually anticipates that exact defensive reaction, and they close the document with a sentence designed to cut through any administrative hubris.
It's a brilliant closing.
The final paragraph states, "These steps will protect both the association and its office bearers from avoidable legal exposure."
Avoidable legal exposure. In the context of everything we have discussed, that phrase carries an immense amount of weight.
It is an incredibly polite, exquisitely sharp legal warning.
It is the strategic masterpiece of the entire document. It is the velvet glove meticulously wrapped around the iron fist of personal liability.
Personal liability.
Yes. Up to this point, the committee members have likely been operating under the assumption that they are protected by the corporate veil of the association. They believe that because they are volunteers acting on behalf of VVRWA, any legal action would be directed at the society, not at them individually.
But the author is systematically destroying that assumption. Right.
Absolutely. By formally submitting this representation, the author has put the committee members on documented notice. They have been explicitly informed, with detailed legal citations, that their actions are ultra vires outside their legal authority.
And once you are notified that you are acting outside your authority, the protections of the organization just vanish.
Exactly. If the committee members choose to ignore this document, if they continue to enforce illegal tenant surcharges or weaponize garbage collection after being formally warned of the legal defects, they are no longer making administrative errors in good faith.
They are engaging in deliberate, knowing malfeasance.
The author is politely reminding them that residents can and will pierce the corporate veil. The board members can be sued personally for damages resulting from their arbitrary and coercive actions.
So the roadmap to reform isn't just a plea for better governance. It is a lifeline being offered to the committee members to save themselves from devastating personal litigation.
It reframes the entire narrative. Surrendering the rule-by-minutes pipeline is no longer a defeat for the committee. It is a necessary, urgent strategy for their own legal survival.
Wow. When we take a step back and look at the entirety of this deep dive, the journey we have been on is remarkable. We started with the mundane frustrations that almost anyone who has lived in a managed community can relate to.
Getting an annoying email from a no-reply address, arguing over who can park where, dealing with a committee member who seems to relish wielding a clipboard.
And we traced how those seemingly minor procedural shortcuts, the desire for administrative speed, the avoidance of friction, the reliance on monthly minutes instead of rigorous rulemaking can compound over time.
We saw how the illusion of due process, simply recording an objection without addressing it, creates a culture of arrogance.
We witness the real-world consequences of that arrogance when it crosses the Rubicon into coercion. We analyze the absurdity of attempting to solve an illegal tenant tax by simply mailing the invoice to the landlord.
We looked at the profound jurisdictional overreach of a committee attempting to charge rent for public roads, culminating in the dystopian reality of a pocket secretary, weaponizing household sanitation to enforce compliance.
And anchoring all of this neighborhood drama, we explored massive foundational concepts of constitutional law. We define the boundaries of ultra-vires action. We examine the critical protective friction required to alter corporate bylaws.
We confronted the dangerous myth of majority tyranny, establishing firmly that an AGM is not parliament and that no local committee vote can extinguish the fundamental property rights guaranteed by the Transfer of Property Act and Article 300A of the Constitution.
The Viviro document really serves as a microcosm for the broader challenges of democratic governance. How we organize and police our immediate neighborhoods is a direct reflection of our internal understanding of justice, due process, and the rule of law.
It is a stark reminder that legitimate authority is not derived from having the loudest voice in the room, nor is it created simply because an action is recorded in the minutes of a Tuesday night meeting.
Think about the various ecosystems you inhabit right now. Think about your homeowners association, your digital community platforms, your local clubs, or your professional committees.
How frequently do we casually surrender our rights, our privacy, or our finances to an administrative body simply because they manage the mailing list or send out the invoices?
The legal representation we analyze today is a powerful tool against that kind of passive surrender. It proves that authority is an illusion if it is not firmly rooted in statutory law and subject to the constraints of natural justice.
The next time you receive an unquestionable mandate from a group you belong to, a new policy that restricts your behavior, levies a new fee, or disables your ability to reply, you might want to pause.
Channel the analytical rigor of the document we explored today. Look past the official letterhead, push past the assertion of majority rule, and simply ask the fundamental question of legal authority. Where is the bylaw? Thank you for joining us on this extensive deep dive. We hope it provided you with a new analytical framework for navigating the bureaucracies in your own life. Keep questioning the structures of authority around you, demand transparency, and we will see you next time.